Article 4. Legislative Branch. The legislative branch directs the powers of the executive and judicial branches by creating guide laws and prohibitory laws. Guide laws are rules and suggestions. They, by themselves, carry no penalty if not obeyed. These laws, such as speeding, parking, safety belts, no camping, and no sleeping, guide the individual's actions in public towards respecting others. If not followed, these actions generally do not violate other people's rights. In cases where the person ignoring the guide law damages others or their property, the person who violated the guide laws shares the greater portion of the fault for any damage caused. Prohibitory laws punish those who are duly convicted of committing the prohibited act, such as murder, robbery, perjury, and other acts that directly violate other people's rights. The Constitution automatically authorizes these types of laws as a means of protecting others from unjust actions, so long as done within the Declaration's authority. This does not authorize general laws that punish the entire population for the criminal actions of an individual. Section 1. The Rule of Law. The rule of law within these United States of America is government according to the supreme law of the land, as described within the 2020 Founding Charter and Constitution for the United States of America, and the legislation enacted in accord with this Constitution. Enacted legislation in honorable governments originates by way of the authority of the governed people's unified voice, which includes the unanimous declaration, so long as two-thirds of the majority of the total body of registered voters' consent has been attained, thus granting those powers to government. Section 2. Legislative Origins. Any lawful resident, whether temporary, permanent, registered voter or not, may propose legislation in accord with the terms of the Declaration. All legislative votes begin in the first house of the smallest level political jurisdictions, which are the cities, towns, and villages, regardless of the larger political jurisdiction that the proposed legislation intends to govern. Section 3. Possession of legislative power. Legislative power resides with the lawful permanent resident citizens who are qualified and registered as voters. Two-thirds majority of the total body of registered voters who, according to the rules of this article, collectively enact all legislation. They determine the fair penalty for punishing offenders in order to discourage future violations. They also establish the manner and amount needed to fund implementation. The reason for the two-thirds consent requirement is to make it difficult for government to acquire power, but not impossible. It should also make it difficult for the people to grant frivolous, fad, or light and transient powers to government. Public safety operators are tested before exercising their right to access public roads, railways, airways, and waterways with their vehicles. Also, those who carry arms in public are tested, indicating knowledge of proper use, storage, and maintenance. For those same reasons of public safety, unity, and honesty in government within these United States of America, citizens are tested before admitting them into a community's permanent resident citizen status. A later test and vote determines whether they may register as voters. The purpose for testing by the existing body of voters is to assure that potential new voters are as well informed as possible, protecting the established resident citizens' body rights as well as their own rights. Subsection 1. Temporary Residency. As indicated here, the United States of America, the government, publishes all government documents solely in the United States of America version of the English language. A person may become a temporary resident in a community if they are a lawful United States citizen or possesses a lawful work, student, or visitor visa. They must be able to publicly communicate in the United States version of the English language. If the person cannot publicly communicate in the United States version of the English language, how secure are existing citizens' rights when new voters do not properly comprehend that for which they vote? The temporary residency period in delaying voting rights is security for the existing resident citizens. It makes it difficult for new citizen residents to undermine the community customs with their vote while being a short-time resident. Subsection 2. Permanent citizen residency. This mostly applies to cities and towns with respect to an element of the Uniform Code of Immigration and Naturalization. After being 3 years a temporary resident, the individual may petition local resident citizens, registered voters, permanent residency. Once the individual passes the test and receives 2/3 or more consenting votes, the individual becomes a permanent resident. This is a public test with records kept concerning the individual's knowledge about the 2020 Founding Charter and Constitution for the United States of America and other contracts mentioned in this Constitution. These records are useful when removing a resident from the voter registration for trying to pass laws that violate the contracts listed herein. The 3-year delay also allows the registered voters to better assess the character of the individual before accepting them as permanent residents and potential voters. Subsection 3. Registering as a voter. When accepted into the registration of voters by 2/3 of the total body of existing registered voters, the individual must sign the local copy of the 2020 Founding Charter and Constitution for the United States of America, and be sworn in with the nation's pledge, detailed later in this Constitution, before they begin voting. The registration process registers the new voter's vote in the default voting position of non-consent. If the voter desires some balloted item or candidate to pass, the voter must check in at the polling station to convert their vote to consent to some item or candidate on the ballot. Subsection 4. Exclusions from voting. Any person serving any part of a sentence for which they were duly convicted, as well as any person receiving government benefits, programs, contracts, or bailouts, must not vote until 1 year after release from sentence or off such government assistance. In this way, it encourages the voting body to be as respectful of others' rights and to not be able to vote to themselves additional benefits out of other people's pockets. Subsection 5. Consent voting. To cast a consenting vote, the voter must show a hard copy voter ID issued by the local community. The voter ID contains the voter's recent photo, that is, 12 months or newer, with a set of fingerprints. This is old school, hard copy in a form difficult to manipulate. There is a 3-point check-in and check-out at the polling station. The registered voter uses their voter ID to enter the polling station, the check-in clerk, and then the check-out clerk. Compare the voter ID information with the file information. Finally, a photo of the voter and a fingerprint are taken to compare with the card and the file information. All 3 photos and prints appear on the clerk's monitor and on a monitor above the clerk for the public to witness or challenge. This is a quality control check for the people to keep the polling station as honest as possible. At checkout, when presenting the ballot for the transparent tumbler. Every ballot must contain the same finger digit print as on the photo ID, and additional fingerprint applied at the time the voter deposits the ballot into the tumbler, with a date time stamp on the ballot. In this way, if someone challenges a specific voter, officials withdraw the ballot until finalizing the challenge. There are no private votes on public matters. This is known because of the nation's pledge to each other, their lives, their fortunes, and their honor. All votes, by default, are non-consenting until the registered voter submits a consenting ballot to the polling station during the designated polling time. If a registered voter fails to get a vote to the polling station, their vote must be accounted for as having not consented, because they did not consent. Otherwise, the candidates and their campaign team circulate petition ballots to obtain the consent votes from 2/3 of the total number of registered voters in their jurisdiction. This is by far less costly to the community and demonstrates the candidate's ability to organize and lead people to accomplish a given task. This also requires that each signature be notary verified against a certified voter checklist. Subsection 6. Purging the voter register. All registers are 100% purged of every name, every year, right after the last voting for that year, so as to remove the names of all dead people, people who moved out of the district, people serving any part of a sentence when duly convicted, and people receiving government assistance or participating in any government assistance program. All voters from the purged register, except for the exceptions listed, may re-register without being retested. Automatic retesting occurs on the voter's 10th year resident citizen anniversaries, as well as testing those purged from the register who did not re-register within 6 years. Section 4. The First House. The first house consists of all lawful residents who are eligible to vote and registered as a voter. The consent of the governed works in this manner, that to secure the people's rights, they institute governments among themselves. Their governments derive its just powers from the consent of the 2/3 majority of the total body of people registered as voters. Consent of the governed demands completing the following 3 elements in the following order. Subsection 1. Equality. The proposed government power or the election of a candidate must serve to preserve the rights of all the people equally. If it does not, it must never go to ballot for a vote. Subsection 2. Exercising political power. If an individual, while exercising a proposed power, cannot do so without unjustly violating others' rights, the issue should never go to ballot for a vote in order to allow government to violate other people's rights. Subsection 3. The vote. Only after successfully passing the tests of elements 1 and 2 just previous, may the proposed power or candidate go on the ballot for voting. Not that they must, but that they may. In element subsection 3, whatever or whomever is on the ballot must attain the consent from at least 2/3 of the total number of registered voters in that political jurisdiction, such as a city, town, county, state, or nation. Of those eligible to vote, only those who desire to have their vote counted must register as a voter. Otherwise, persons eligible to vote but do not register as a voter will not have a vote counted. Citizens possess the right to not participate in voting. Every registered voter's vote must be counted as not consenting or as consenting. Any person registered as a voter and desires to not vote, that person must remove their name from the voter register. Registering as a voter creates a default non-consenting voter position until such time the voter gets a ballot to the polling station to consent to some item or candidate on the ballot, or submitting a write-in selection, which must be counted regardless of how few votes. Otherwise, their vote must by default count as having not consented until they convert it at the polling station to consent. If the total number of registered voters who consent is less than 2/3 the total number of registered voters, everything and everyone on that ballot must fail for lack of consent. When the balloted item fails, it is not enforceable, or the candidate must not take office. This prevents voters from feeling the need to vote for the lesser of evils, which, by definition, is an act of treason by adhering to and giving aid and comfort to an enemy. The voter selects a candidate that they consider will destroy the political jurisdiction just a little less than the other options. The minimum votes establishes the minimum quorum required by this Constitution, which is 2/3 the total number of registered voters. This does not change the fact that it still requires 2/3 of the total body of registered voters to elect or pass any balloted items. Government officials may only exercise those powers that protect the rights of the resident citizens equally. Any individual must also be able to exercise, in the absence of government, any power granted to government. The absence of government can be as small as waiting for police to show up, or as major as government officers who refuse to take constitutional action when needed. Section 5. The Second House. Each larger jurisdiction's second house consists of the total number of immediately junior or smaller political jurisdictions within it. 2/3 of the second house votes must consent in order to pass in the second house of each larger political jurisdiction. Each lower-level jurisdiction has one vote in the next larger jurisdiction's second house. The second house vote is automatically determined as consenting or non-consenting based on whether 2/3 or more of the total body of registered voters within that lower-level jurisdiction consented to the balloted item or did not consent. If only 50% of the total number of registered voters consent to a balloted item or candidate, it must fail for lack of consent by not attaining the 2/3 consent required. Section 6. Legislation's required elements. All of the following elements must be present in every legislative act. Subsection 1. Protect rights. A free society limits legislation to the purpose of protecting one person or group of people from unjustly violating the rights of another person or group. Harm consists only in tangible, personal, bodily, and financial harm to a person or property. The person harmed must prove to an impartial jury that the claimed damage exists and that the person accused did that damage. Subsection 2. Preamble. All legislative acts must contain a preamble that identifies what part of this Constitution, or elements of the supreme law of the land, authorizes the legislation and how the proposed legislation improves the political jurisdiction governed by the legislation. This will also identify the original jurisdiction. Subsection 3. State the specific penalty. All legislation that does not specify a penalty punishing violators and does not specify the manner by which to fund its enforcement is unenforceable. A range of penalties must not exist. An honest justice system is not a lottery. The penalty for doing the same prohibited action must be identical regardless of who does it. An individual convicted of the same type of crime after a prior conviction for that type of crime may receive a harsher penalty, which also must be detailed within that law. The law must specify the penalty for a repeat offense against the same law, such as murder equals murder, premeditated, or in the heat of anger. However, self-defense does not equal murder, and robbery does not equal murder, etc. The goal is to get people used to controlling their own emotional outburst so that they do not damage person or property. Subsection 4. One issue. All proposed legislation must contain only one clearly defined issue, which is the title of that legislation. Subsection 5 requires yes votes to pass. All proposed legislation must be worded in such a manner that a yes or consenting vote favors the proposed legislation. Subsection 6. Expiration date. All proposed legislation must contain a fixed date, less than 12 months, by which the proposal passes, or it dies for lack of consent. It must also include a specific date to review it for reinstatement. If not reinstated prior to the expiration date, it dies as if actively repealed. Subsection 7. Signature ballot. The signature ballot is circulated to attain signatures. It must get at least 2/3 of the total number of registered voters to sign the ballot, consenting to the ballot item or candidate. The signature votes must be verified against certified voter registration list by a notary who verifies the identification. The balloted item or candidate takes effect immediately upon verification of receiving at least 2/3 consenting signatures. As opposed to polling stations, at the national level, signing events may be scheduled for a period not to exceed 12 months. If the signature ballot is unable to attain the required consenting votes within that 12 months, it fails automatically for lack of consent. Smaller political jurisdictions may, in their respective constitutions, reduce the amount of time a signature ballot remains open, but may not exceed 12 months. Subsection 8, worded identically to advance. Advancing legislation into progressively larger political jurisdictions, when passed within each smaller level jurisdiction, it must be worded identically, including the penalty and manner of funding, as well as other criteria listed above. Subsection 9. Reintroducing failed legislation. To prevent failed legislation from being resubmitted too frequently, it may not be resubmitted for at least 2 years after its last failure. Simply rewording the content does not qualify as a different proposal. Subsection 10. Funding. As for legislation enacted or candidates elected in only one town, only the people of that town must fund and enforce it. The same applies for counties, states, and nations. No other political jurisdiction's funds may go to that of another political jurisdiction unless the people of the other political jurisdiction specifically grant their consent to participate. The only exception to this rule is when 2/3 of the larger political jurisdiction have consented in accord with the terms of the declaration. Section 7. Checks and balances. The two-house system prevents the larger populated jurisdictions from controlling the smaller ones. It also prevents the more numerous smaller jurisdictions from controlling the fewer but larger ones. This 2/3 rule slows down the process by which government gets its power. Section 8. Equal media time. The news media is a public trust, as they are expected to report issues and events impartially. Each publication or broadcasting business independently determines the space and or time allotments within their respective coverage area and media format. Whatever an organization decides for themselves, they must provide equal time or space for every candidate running for the same office during the same election. This also requires equal time or space for opposing sides of legislative proposals. To maintain the freedom of the press, the respective media owner may choose to provide no media time or space at all for any political purpose or vote. However, as a public trust, if they provide media for one side of an argument or for one candidate where there is more than one, that media outlet must provide equal time and or space for the others. Section 9. Campaign debates. The political jurisdiction holding the general election pays for the question and answer forums and debates, which must include all registered candidates willing to participate. Candidates not participating in the forum disqualify themselves from being listed on the ballot in that election cycle. Voters may write in any candidate's name not listed on the ballot. All candidates, including write-in candidates, are prohibited from buying advertising, thus making the media coverage more impartial as well. The larger political jurisdiction holding the election must organize and fund the forum. They must provide round-trip transportation for each candidate to get from their voting resident City Hall office to the location where the forum takes place. The jurisdiction sponsoring the debate solicits questions from the people within the jurisdiction that the office covers. The moderator organizes the questions according to topic, asking the questions that best address the issue. During each forum, the moderator allows equal time for each candidate to respond. Time allotment may differ for each question. Candidates who are situated in soundproof cubicles do not hear responses from other candidates until after the moderator asks all the questions in this forum's first half. In the second half, candidates may challenge and debate each other on specific topics. The moderator also times these debates according to the time agreed to by the candidates prior to each debate. Each phase runs until complete in marathon fashion with a 10-minute break every hour. All question and answer sessions and debates are video and audio recorded for broadcasting. They are also transcribed for print publication, Braille, International Morse Code, and International Sign Language. The recorded audio-video footage and transcripts from the question and answer forums and debates in their entirety must be commercially available for sale to the public. A number of copies are to be made available to public libraries in the district. The proceeds from selling copies of the recorded forums and debates, as well as revenue from advertisers during the recording breaks, helps fund the forums. Interested advertisers are chosen by lottery. Section 10. Ranked voting. Ranked choice voting is another way to quickly reduce the number of candidates to fill the open seat. The candidate receiving 2/3 of the number one vote has been selected. Debates take place the same as above. Section 11. Elimination voting. When an election encourages a large number of candidates, elimination voting takes place. 60 days after each question and answer debate forum, an elimination vote takes place. The 25% of candidates receiving the highest vote count advances to the next round. The election process continues until one candidate or the required number of candidates to fill the vacant seats acquires 2/3 or more of the votes of the total body of registered voters consent. A voter who truly does not want any of the balloted candidates in office simply does not submit a ballot or marks the balance of the ranked votes as none. When the none or number of unsubmitted ballots is the majority, the registered voters must seek out a suitable candidate or leave the office vacant. Section 12. Polling station hours. For general election voting, all polling stations within the same political jurisdiction that span only one time zone must open and close at the same time, remaining open during the same 24-hour period. For political jurisdictions that include multiple time zones, all polling stations must open according to the hour of the earliest time zone and must close according to the hour of the latest time zone. In this way, all polling stations remain open the same 24 hours plus 1 hour for each added time zone. An alternative would be to have the signing ballot set up in the local government office throughout a 7-day period for people to sign if they desire to consent. At the end of the deadline, if it has not received the required consenting votes from the total number of registered voters, it fails for lack of consent. Section 13. Voting method. Briefly introduced earlier, the signature ballot works best with recall elections and legislative proposals. It keeps the cost of voting minimized to the person or party seeking to recall a particular government official or government act. This requires the party initiating the recall or initiating the legislative proposal to get the required 2/3 majority of the total number of registered voters consenting signatures verified. Section 14. The general election and recall election tally sheet. The tally sheet is concerned with 3 primary elements of voting: total number of registered voters, only the total number of consenting votes, did 2/3 or more of the total number of registered voters consent to the same balloted item or candidate. Section 15. Broadcasting, publicizing vote results. For general and recall elections, early broadcasting or publishing of the actual exit poll predictions, the numbers or percentages of party voters, or predicted or actual voting results in any form until 24 hours after the polls officially close is an attempt to manipulate the results of the polling process. Such actions will be treated as a felony, high crime, and an overt declaration of war against these United States of America. Section 16. Enacting legislation. All legislative votes begin in the first house with the people in the smallest level political jurisdictions, such as cities, towns, villages, etc., regardless of the jurisdiction level that the proposed legislation might eventually govern. Proposed legislation passes in the first house of the smallest level political jurisdiction when 2/3 or more of the total number of registered voters vote yes, consenting to the proposal. The second house vote for the smallest level jurisdiction is an automatic yes, consenting, when 2/3 or more of the total number of registered voters of the first house approve the proposed legislation. Otherwise, the second house vote is no, not consenting. The first house tally sheet and the second house vote tallies from each lower level political jurisdiction must accompany a copy of each legislative proposal, whether it passes or fails. The lower level jurisdiction transmits this package to the next larger level jurisdiction. The executive office of each next larger level jurisdiction accumulates, tracks, coordinates, and adds the votes regarding lower level jurisdictions. Based on the actual vote count, determines whether that legislation passed in the larger political jurisdictions according to the rules of this Constitution. Each political jurisdiction keeps a copy of the legislative package and vote tallies for their records as they send a package to the next larger political jurisdiction. When the proposed legislation passes in both houses of the next larger political jurisdiction, the larger jurisdiction sends the legislative copies to all lower levels to inform them that the legislation now affects the entire larger level political jurisdiction, including those that may not have considered the legislation. This legislative process advances into each progressively larger political jurisdiction as detailed above. If the legislation remains unchanged as it advances into each larger jurisdiction, the smaller jurisdiction's people need not vote on the issue with each advance. If the legislation changes, the smaller jurisdiction must vote on those changes if it has not already passed in both houses of the larger. In order to enact proposed legislation to a specific political jurisdiction, both houses of that jurisdiction must attain 2/3 or more yes consenting votes. Without the required 2/3 majority, the proposal fails, and it is not enforceable in the lower level political jurisdictions that passed it, unless the lower levels enact the proposed legislation stipulating to allow its enforcement, even if it failed for the larger jurisdiction. To enact legislation to a specific level political jurisdiction, the proposed legislation must state the specific date by which to enact the proposal. If not enacted by that set date, it automatically fails. If political jurisdictions are added or removed while a vote is in progress, those changes in jurisdiction numbers must be included in the calculations, just as adding and removing registered voters alters the calculation in the first house. This process does not guarantee or require that every registered voter approve the proposed legislation. It promotes the greatest participation by the people to improve each proposal before it advances into each larger political jurisdiction. This process eliminates the rule of the few over the many, or where indirect legislative representatives migrate toward refusing to represent their respective constituents and lean more towards personal gain. This process allows free citizens united in a political body to withdraw their vote, if done so prior to the final calculation and ratification of the balloted item or candidate, thus the need for identification on each ballot. If people learn critical contrary information not available prior to voting, it allows them to change their vote before the final count. Section 17. Electing officials. For every election, runoff election, or ranked voting, a single ballot issues listing every candidate on the ballot who registered for the office. Candidate names appear on the ballot in random orders so that each candidate appears in different places on different ballots as equally as practical. Ballots must not contain any political party affiliation, officers' prior or current titles, or any other identification for any candidate other than their last and first names. The governed people, via 2/3 of the total body of registered voters, directly elect the executive and judicial officers for their respective jurisdictions via the two-house system. In addition to receiving more votes than any other candidate during the same election for the same office, the candidate who takes office must also receive 2/3 or more consenting votes from the total number of registered voters from within that political jurisdiction. This means that the successful candidate must receive more votes than the combined total of the registered voters who did not cast a consenting ballot for the same office. In this manner, the people are not obligated to vote for the lesser of evils. If no candidate receives 2/3 or more consenting votes from the total number of registered voters, the executive officer must order a new election. The new ballot lists all new candidates, excluding the candidates' names on the original ballot, but may include write-in candidates who accepted a nomination. The elected officials within their branch and political jurisdiction work together to successfully carry out the duties approved by law while also working on the constitutional plans and promises they proposed while campaigning. Voters approve candidate promises up to the point that those proposals do not conflict with the supreme law of the land. When electing a candidate, voter approval allows officials to develop plans concerning the amount and manner of funding and implementation of the proposed projects, all of which requires additional legislative approval before implementation. Section 18. Standard term limits. Standard term limits for executive and judicial officers are 1 8-year term in any 10 consecutive years, with a person serving in the same office no longer than 24 years in the same political jurisdiction. This prohibits back-to-back terms. Ideally, but not required, the people might promote, via election, their best qualified leaders from within the smaller political jurisdictions into the larger political jurisdictions in both the executive and judicial offices. If an elected person becomes corrupted against this Constitution, the people should remove that politician by way of a recall signature ballot. Recalls may occur at any time that people consider that government officer needs to be removed before the end of their contracted elected term. Section 19. Political retirement benefits. There are no retirement benefits once a person leaves office from any occupation of government, with the exception of the active duty military service, so long as they honorably served the nation's people in combat during an active, constitutionally declared defensive war. These benefits are limited to all medical needs that resulted from active wartime military service, in addition to receiving up to 50% of their base pay for the rest of their life. The wartime veterans who die in combat, their immediate family, spouse, and or children must receive for a period of up to 20 years 50% of the veterans' base pay. Section 20. Heirloom offices. At least 3 generations should separate other family members who served in the same political office, jurisdiction, and government level that the candidate seeks. This reduces the ease by which political offices and power become family heirlooms. The 2/3 vote requirement also helps reduce the likelihood of political offices and power becoming family heirlooms. Section 21. Grant of authority. Upon election, executive and judicial officers obtain the lawful authority to act on the people's behalf within their respective political jurisdictions, but only so far as the respective Constitution and constitutionally enacted legislation permits. An election does not automatically grant authority for an official to enforce or otherwise complete campaign promises that conflict with this Constitution or other enacted legislative authority. Without constitutional authority for their actions, elected officials risk being recalled and or prosecuted for treason. The people may grant or revoke any political powers via their sovereign authority through legislative action, which becomes effective and part of this Constitution as determined in repeal and amendments. This alters the powers of any official in office at the time of the enactment. The only voter mandate that exists from the people to any government official comes by way of the lawful amendment process detailed in this article. Just because a candidate receives the consenting votes from 2/3 or more of the total number of registered voters to take office, this does not authorize the candidate, when elected, to work on any project that violates this Constitution. Section 22. Emergencies. The executive or judicial officers of the affected political jurisdiction may call an emergency legislative session in cases where existing legislation does not already grant to them the required authority to resolve those situations claimed as an emergency. If an officer abuses the emergencies clause, the people reserve the right to remove the politician from office and nullify unjust acts, resolutions, decisions, contracts, etc., initiated by those politicians. In the same manner, any government officer, employee, volunteer, contractor, or others working on behalf of a government officer or agency can be removed from office for violating this Constitution before the end of their term. Section 23. Impeachments and recalls. The simple majority vote of the total body of registered voters holds the sole power of impeachment and recall of government officials, whether the official is elected, hired, appointed, under contract, or any other manner works in or for government. The simple majority proposal is intended to make it easier to undo unjust government when it happens. Recall signature ballots must state in less than 200 words the cause for the impeachment or recall, as well as the remedy sought. This ballot is circulated among the body of registered voters to acquire their consenting signature, which must be clearly stated that what they sign is a signature ballot, and that it must acquire a simple majority of consenting signatures from the total body of registered voters before the ballot becomes lawfully enforceable. Signature ballot signatures must be verified by way of the two-step process that includes Subsection 1. Certified Voter Registrations Checklist. The voter registration checklist must be verified by the clerk of voter registration as being complete and accurate as of the date delivered. Subsection 2. Notary verified consenting signatures. The impeachment and recall ballot, in addition to the 200-word cause for removal, must also provide 200-word rebuttal space from the official subject to the recall. The official will state the reason for their actions and why they feel they should not be recalled. This is not required, especially if the government officer refuses, but the refusal must be noted. The recall and impeachment vote must acquire a simple majority of the consenting votes of the total number of registered voters in order to be enforced. The same election process, with debates between the candidates, shall take place no later than 30 days after consenting signatures reach 25% of the total number of registered voters. Section 24. Repeal and amendments. Repealing or restricting government powers within this Constitution do not become effective until after reaching a simple majority of consenting votes of both houses within this nation. Otherwise, amending this Constitution to grant powers must attain 3/4 of both houses to consent, as detailed in earlier sections. Section 25. Other powers. The registered voters in their respective political jurisdiction to which any enacted legislation has attained will approve taxation in both the budgeted amount and the manner collected, being required as part of the legislative process. The body of registered voters will determine the wages and benefits for their respective elected officials and pay range for their other government employees. The legislative body may grant pardons, and all other duties as legislators of right may do according to the rules of this founding charter and constitution. Pardons, being considered a recall activity, must attain consenting votes from a simple majority of the total number of registered voters in the respective jurisdiction to enforce the pardon. Section 26. Risk and Wars. All citizens collectively risk their lives, fortunes, and or honor in wartime. The registered voter citizens of the political jurisdiction must be the ones who decide what wars to join or continue defending, so long as to not violate the powers honorably granted to the larger political jurisdiction. The executive officers automatically possess power to defend their respective political jurisdictions against any defined enemy, foreign or domestic. In cases where a cyber attack occurs, the government has the duty to investigate, as with any other types of attack, to discover the source of the attack, whether it be an individual, organization, business, or government. No wars against things like drugs, illiteracy, poverty, etc. In order to engage in a war that defends people of other countries, when these United States of America are not under actual attack, requires 2/3 of the total number of registered voters' consent, unless a specific level of assistance is authorized beforehand by way of a treaty agreement made in accord with the unanimous Declaration of the United States of America. Section 27. Benefits. The people of the cities, towns, villages, and upward become aware of legislation as it happens, because it works its way up from smaller jurisdictions into the larger. The legislative system employs far fewer people in government offices and agencies by abolishing the elected legislative branch in all political jurisdictions. It eliminates most of the cost of legislative staff and most of the operating expenses, while also abolishing most of the wasteful political spending. This single step redirects trillions of otherwise wasted tax dollars by the nation's government into worthy projects and programs, allowing taxpayers to retain more of their financial reserves. Legislation must be written for the people to easily and properly comprehend without the need for legal translators and specialized dictionaries. Therefore, all words defined in any way must be in accord with the common use definitions that existed as close to and just prior to the date being submitted for vote, unless otherwise defined in this Constitution. This legislative system reduces court overload from people who violate laws that they either do not know about or do not comprehend. For words not specifically defined in this Constitution, a common use dictionary in hard copy print of the time prior to being submitted for vote must be used to define those terms within. Where the Constitution defines specific terms, these definitions must apply to all legislation and government offices at all government levels and branches to maintain consistency throughout government offices and society. Legislation slowly advances into larger jurisdictions. It allows for improvement to occur in the lower levels where it is less costly to implement and test. The requirement for attaining 2/3 or more of the total number of registered voters prevents smaller groups within a political jurisdiction from passing special interest legislation behind closed doors. It requires the greatest degree of publicity and voter participation and consent before proposed legislation or candidates become official. Section 28. Voting holidays. For general elections, there must be at least 4 voting holidays set aside as local and national holidays, one for each quarter of the year. Not that a vote must be done with each one. These days replace 4 other national and or local holidays, be they political and or religious. See also the alternate to this, where the party initiating a ballot item, candidate, or recall then circulates signature ballots to attain the required 2/3 consenting votes.